we jump on to unfair dismissal, okay, which is always an interesting topic. So what can you tell us about unfair dismissal and what it actually is?
Okay, so what's important to know about unfair dismissals is that, as I said before, the number of cases has gone from around 5,500 back in the mid-2000s, 2005, 2006, to just over 14,000 cases now. We read yesterday in the Fair Work Australia report. An unfair dismissal is a dismissal where you have dismissed someone in circumstances which are called harsh, unjust, or unreasonable. And the Act does contain a list of factors to help you decide whether the circumstances are harsh, unjust, or unreasonable. But unfortunately, the last of those factors is any other matter that Fair Work Australia believes is relevant in the circumstances. And the case I'll give you on that, as a practical example, this is a case called Pork and Living versus Mills Scott Paper Mills. My pronunciation of Mills Scott is always wrong, as my Scandinavian friends tell me, but that's the best one I can do with Aussie. And this is a paper mill that's based out of Albury. And what happened there was Pork and Living was the employee. He was told to go into this paper vat and clean it out one day. That was his job. He was trained to do it. He was given certain safety equipment, goggles and gloves, etc. And the employer went down and checked on Paul after about 15 minutes and found that Paul had taken off the safety goggles. So the employer, of course, told him to put them back on. The employee swore at the employer, that was documented in court later on. And this interaction happened 4 times. So on the 4th occasion that the employer went back to check how Paul was doing, he found that the goggles had come off. And in that time, he dismissed him on the spot and said, "We're in New South Wales, we have the toughest health and safety laws in the world. I'm not going to go to prison because something flies into your eye and you go blind. So, that's not going to happen on my watch. So, as far as I can see, they're not following my reasonable instruction. I have to let you go." So he dismissed Paul. Now, Paul took this case to the tribunal and he won. He won, I think it was, off the top of my head, $13,000 in back payments, back to the date that he was dismissed. But more importantly, he was awarded his job back. So he was reinstated. And it's important to note that under the Fair Work Act, reinstatement is to be Fair Work Australia's preferred outcome in an unfair dismissal. So if they can give the person their job back, that's the ideal outcome at Fair Work Australia, because they've been put back into the position they were in before you unfairly dismissed them. But what is really crucial in the case were the 4 reasons that the Commissioner gave as to why the dismissal was unfair. And the circumstances fell under that last category of any other matter that Fair Work Australia believed relevant. The Commissioner said the dismissal was unfair at law because Paul Quinlivan's wife had depression and it was made worse by him not having a job. Paul had 2 teenage daughters, and teenage daughters are expensive to raise, and how could he fund them or take care of them if he didn't have a job? The third was that Paul Quinlivan had never finished high school, and therefore he had, quote, limited life opportunities, so the employer should have factored that in. My favourite one is the 4th one, because I think we can all relate to this, and that is that Paul Quinlivan owed $70,000 on his mortgage, and it was a big financial burden on him to meet those payments without a job. That was my personal favourite. Well, and what's interesting about this case is that it was just at Fair Work Australia before a commissioner, so it doesn't become a binding precedent, if you like. So there have been other cases afterwards where those sorts of factors have been argued and been dismissed by the commissioner as irrelevant and won't be taken into account. But in that particular case, what we saw was the breadth, if you like, of factors that the commissioner would be willing to consider. And really what that case turned on was the fact that Paul Quinlivan had worked there for a very long time, and there was nothing else really against him in his employment record. So I suppose when you look at the balance of all the different factors, those 4 things weigh heavily in the Commissioner's mind. Now I can't, it's not appropriate for me to speak negatively about a duly appointed Commissioner, so there was reasoning behind it, etc. But I'm very concerned by that logic, because I don't know how many of us will be dismissing someone. I've certainly dismissed people. I don't normally precede it by, just before I do, people tell me how much do you owe on your credit card. How's your partner doing? Well, apart from anything else, it would be an offence, really. It's probably illegal for me to ask those sorts of questions because it opens up the world of discrimination. Yeah.
You just seem to be missing the safety issue of the actual employee. Not worried about anything.
Yeah, that's right. I mean, the employer argued that they were coming from a good place. This was all about protecting the employee, trying to take care of them. And the employer also argued, in New South Wales, we have incredibly strict workplace health and safety laws. We led the country, really, in those laws. And, the argument was we're trying to obey those laws by enforcing this policy. What sort of message does it send to everyone else in our workplace that this employee is able to do this? Unfortunately, in that case, it didn't work. So the message out of that case, the other thing the Commissioner said was, interestingly, on that 3rd occasion, if the employer had said to Cork and Living, if you take those goggles off one more time, I will fire you. If they had made it expressly clear, according to the commissioner, because what that would have done is it would have truly brought home to him the likely consequence of him disobeying the instruction. So it would have removed all ambiguity. And the commissioner said, had that happened, that would have outweighed all of those other factors. You know, I mean, who's to know in the circumstances that that's what's going to turn on? But it just goes to show the message here is that you should follow a proper process when you're dismissing someone, and really, really keep it through. No. Yeah, no, it wouldn't be a defence. I mean, unfortunately, none of these things go in the employer's favour. Yes, you are. Absolutely. And that's the, you know, the comment that we consistently make on behalf of employers, certainly Workforce Guardian, that we do think the legislation is very lopsided. Not simply because we've got the Fair Work Act and all of these things that are associated with it, but at the same time, you've got these incredible compliance burdens from the tax office, etc. You've got VAS and all these things to do, but then you've got workplace health and safety laws, you've got discrimination laws coming in, you've got superannuation obligations, so all of these things are stacked up, if you like. And you do start to wonder, is it worth running, you know, a small business in Australia? Is it worth me really employing anyone? Because I'm facing all of these penalties all the time as a company owner. Maybe I'd be better off just going and being someone else's employee, you know, and getting my super paid. And I'm the managing director of the business, so no one's paying my super. But you know, quite nice if, you know, if I got 4 weeks of paid annual leave. I don't remember the last time I had 4 weeks off. I don't know about any of you. You know, sometimes it goes through your mind. And really, what it is about is making sure you're on top of these compliance obligations and finding ways to do that, just as you have with your financial obligations through your accountant. I'd really recommend you do the same with your employment relations.
It doesn't matter how many rules are in place, there's always that bottom line. All else. So all the listings that apply in that
Yep.
right, that bottom line says this is still doesn't matter if you've done that.
Yeah, and the best, I like that done. I'm going to use that one. The best defence I can ever say to any of our clients, and the best defence I lodge in the tribunal on behalf of clients, is to say, this is the process that my client followed. So my client didn't simply say to the employee, you're rubbish and you're fired, and march them out of the business. Here are the warnings that my client gave. Here were the letters. Here were the offers of support that my client gave to the staff member. These were the documents of the discussions that they had. Here is when they were offered the opportunity to have a representative come in and assist them. Here's the offer of training. You know, like those sorts of things. Here are the contemporaneous notes that my client took each time they had these difficult conversations with the staff member. All of those things work in your favour because it shows that you were thinking about the proper process that you should be following and that you attempted to apply what we call natural justice. You know, it doesn't always mean that you'll win, but it does certainly mean usually that you'll have a reduced penalty, because the maximum penalty that you have to pay is half of the high income threshold or half of that employee's annual earnings, whichever is the lower.
We learned years ago, this accident.
Yeah.
I ran a couple of employees from spot they had set up and you can make these transfer data and everything. One day I went to
And that's precisely what we mean. It's a great
that
example.
was on about 15 years, so
Yeah.
it's been in for a while.
Yeah, under the old awards as well.
Yeah. So you've got to I look at the judgment, the arbitrator, and I think, stones around it. You'll just be caught in stuff. You had it in your diary every time. Get away from that thing.
The only, I can say this, is I occasionally, we have some American-based clients who have employees in Australia, and quite often making the case to an American company as to why they should have a service like Workforce Guardian, they don't get it, because they say, well, you know, we have, in America, we have 2,000 employees and everything's fine. You know, I don't see why we would need to have a specialist service in Australia. And I say to them, sure, okay, did you know that in Australia we have leave loading for most employees? What's leave loading? And I say, So in Australia, what we do is when someone has a holiday, we pay them more. And you can hear there's this 30 seconds of silence on the line where I'm not sure whether they've hung up or, you know, and then they come back on and they go, no, sorry, I thought you said you had to pay them more on the holiday. And I said, exactly what I said. And they said, how much more? 17.5% in most cases. And again, there's this 30 seconds of silence. And you can hear talking in the background, like, you know, is this guy that was speaking completely lunatic? I'm like, where did we get this guy? And then they come back and, you know, they finally get it. I send them through the documents. And they don't understand that in Australia we have this completely regulated labour market where all of these choices that you might have had don't exist. So it is regulated.